There is a persistent myth inside executive suites, particularly those insulated by layers of legal counsel and institutional habit, that termination without cause is a clean operation. A memo is issued. Access is revoked. The individual is escorted out. The balance sheet absorbs the severance and the organization moves forward, unchanged and unexamined. That belief survives only because most executives have never had to read their own governance documents under pressure. I was terminated without cause on a Tuesday morning, following a board call that lasted less than 12 minutes. The justification was delivered with a tone that suggested procedural inevitability rather than deliberation. Strategic realignment, leadership refresh, the usual corporate euphemisms that signal neither wrongdoing nor competence, only impatience. No performance deficiency was alleged. No breach was cited. The decision, I was told, was final. From a legal perspective, this was unremarkable. From a governance perspective, it was reckless. Because termination without cause does not mean termination without obligation. It means the company elects to sever the relationship while accepting the financial consequences embedded not in employment law, but in its own internal architecture. Bylaws, indemnification clauses, legacy provisions drafted during earlier, more cautious eras of corporate stewardship. These documents are rarely read with care once a company reaches operational maturity. They are amended for compliance, not comprehension. That was their mistake. The severance package presented to me reflected the company's current executive template: base salary continuation for 6 months, accelerated vesting on a narrow tranche of equity, and a non-disparagement clause drafted with all the imagination of a parking citation. It was efficient, it was modern, it was also incomplete. What made it incomplete was not what it included, but what it ignored. Several years earlier, long before the current CEO consolidated authority, the company had adopted a bylaw intended to prevent abrupt leadership purges during hostile takeover scenarios. It was a defensive measure, drafted with almost operatic caution, designed to disincentivize impulsive removals by imposing ongoing financial obligations tied not merely to the terminated executive, but to the position itself. That distinction matters. The bylaw did not guarantee my job. It did not prohibit termination. It did something far more inconvenient. It required that compensation for the role continue uninterrupted for the remainder of the original appointment term, regardless of who occupied the seat. In other words, if I was removed early, the company owed the salary twice, once to my successor and once to me. This was not widely known. It was not cited in any recent board materials. It existed quietly, dormant but enforceable, like a loaded instrument locked in a drawer everyone forgot to check. And under the weight of this liability faltered the CEO, though not immediately and certainly not publicly. At the time of my termination, I did not mention the bylaw. I accepted the paperwork. I asked no questions. I thanked the board for the opportunity. It's remarkable how disarming politeness can be when paired with preparation. Only later, once the successor was announced and payroll allocations were updated, did I notify counsel that the company had triggered a dual compensation obligation it could not retroactively unwind. This was not retaliation. It was arithmetic. The company had believed it was executing a clean separation. In reality, it had initiated a long-tail liability with no operational upside. And that error, small in appearance, elegant in consequence, would define everything that followed. Corporate bylaws are written in a peculiar language. They are not aspirational, like mission statements, nor tactical, like operating manuals. They exist in a liminal space between fear and foresight, often drafted in moments of institutional anxiety. Mergers, proxy battles, regulatory shifts, then left untouched once the threat passes. Executives assume they are obsolete. Lawyers assume someone else has reviewed them. Boards assume they are harmless. This particular bylaw was anything but harmless. It had been adopted nearly a decade earlier, during a period when activist investors were circling, and the board feared a rapid decapitation of senior leadership as a means of value extraction. The solution they devised was structural friction. Any early removal of a designated executive role would preserve the compensation obligation for the full term, irrespective of replacement. The logic was straightforward. Make disruption expensive, and opportunism becomes less attractive. What no one anticipated was that the mechanism would later be activated not by external aggression, but by internal arrogance. The language was precise, almost obsessively so. It did not reference individuals, it referenced offices. It did not require cause to trigger. It required only early termination, and that explicitly prohibited offsetting payments against successor compensation. There was no ambiguity, no discretionary escape hatch, no material adverse effect clause lurking in the margins. When my counsel raised the provision with the company's legal team, the initial response was disbelief, followed by irritation, and then, inevitably, silence. Internal review took weeks. External opinions were commissioned. The conclusion, when it arrived, was quietly devastating. The obligation was real, enforceable, and already accruing. From a financial perspective, the numbers were uncomfortable but not catastrophic. From a governance perspective, the implications were worse. The company had publicly justified my removal as a strategic necessity. Privately, it now faced a reality that the decision imposed a recurring cost with no strategic benefit whatsoever. Every month that passed, the balance sheet carried a reminder of that miscalculation. The successor, meanwhile, was being paid normally, competently even, which made the situation exquisitely absurd. The company was compensating 2 people for 1 role, one of whom no longer contributed anything beyond the silent enforcement of a rule they had failed to respect. It was governance theater at its most expensive. There were attempts, of course, to negotiate, proposals to restructure the obligation, suggestions that the bylaw was no longer aligned with current corporate realities. One particularly creative argument implied that continued payments violated fiduciary duties to shareholders. That argument collapsed instantly, because fiduciary duty does not permit ignoring binding obligations simply because they are inconvenient. The board eventually understood what the executive team had not. This was not a legal problem to be solved, but a lesson to be absorbed. The bylaw had done exactly what it was designed to do. It punished impulsive authority. It rewarded institutional memory, and it exposed the difference between power and control. In my professional judgment, and I offer this without hesitation, the attempt to terminate without fully understanding the company's own governing framework was not merely careless, it was incompetent. What ultimately forced the issue was not legal theory, nor reputational risk, nor even the quiet embarrassment spreading through the boardroom. It was cash flow. By the 3rd payroll cycle following my departure, the accounting anomaly could no longer be disguised as a temporary reconciliation error. 2 compensation streams were leaving the company each month, mapped to the same executive cost center, justified by 2 entirely different rationales, one operational, one contractual. Finance flagged it. Audit noticed it. And once audit notices something, it stops being a private inconvenience and becomes a documented fact. This is where governance failures become visible, because money is less forgiving than hierarchy. The CEO's authority was never in question. His judgment, however, was. The decision to remove me had been framed as decisive leadership. In practice, it had created a standing obligation that reduced financial flexibility, complicated forecasting, and, most critically, could not be explained to shareholders without revealing that the company had failed to understand its own rules. That disclosure was never made. Instead, the cost was absorbed quietly, quarter after quarter, as if silence itself could amortize embarrassment. There was an internal attempt to reinterpret the bylaw. That effort failed quickly. The language resisted reinterpretation with a kind of austere indifference. It did not care about intent. It did not care about optics. It recognized only sequence: appointment, term, premature removal. Once those conditions were satisfied, obligation followed, relentlessly. At one point, a senior executive suggested that continuing payment might incentivize others to exploit legacy provisions. This revealed more than it concealed. The concern was not that the provision was unjust, but that it worked, that it constrained power, that it imposed memory on a leadership culture accustomed to operating in the present tense. The successor, by then, had settled into the role. Performance metrics were stable, which meant the company faced a uniquely inefficient scenario: operational continuity paired with financial duplication. There was no upside left to extract, no narrative left to sell, only cost. And so the conversation shifted, not toward legal escape, but toward containment. I was offered a settlement, then another. Each proposal attempted to convert a long-term, predictable liability into a short-term concession, framed as pragmatism. Each was declined, not out of spite, but out of discipline. The bylaw did not exist to be bargained away under pressure. It existed to be honored or ignored at cost. What the company failed to appreciate was that this was no longer a dispute, it was a demonstration. The board had authorized a structure years earlier to protect the institution from reckless consolidation of authority. That structure had now been tested internally, and it had held. From that point forward, the obligation was no longer questioned. It was booked, forecasted, normalized. A quiet, recurring reminder that governance, when taken seriously, does not negotiate with convenience. And that, in the end, was the most expensive lesson of all. Executives often confuse decisiveness with durability. The former is visible, the latter is structural. One commands attention, the other commands outcomes. This distinction is rarely understood until authority collides with architecture and loses. The CEO remained in position throughout the ordeal. Publicly, nothing had gone wrong. There was no reversal, no reinstatement, no admission of error. Internally, however, behavior shifted. Termination protocols were revised. Governance documents were circulated with unusual urgency. Legal counsel was invited into rooms it had previously been excluded from. The institution belatedly remembered that it had rules. What had happened was not retaliation, nor cleverness, nor even strategy in the conventional sense. It was simply alignment with a system that predated everyone currently wielding power. The bylaw had been written by people who anticipated exactly this scenario. Not the individuals involved, but the impulse, the belief that authority could move faster than obligation. They were wrong. There is a tendency, especially among modern executives, to view legacy governance as ceremonial, something to be respected in principle but overridden in practice. That mindset persists until the moment a forgotten clause asserts itself, calmly, mechanically, without regard for ambition or narrative. When that happens, hierarchy becomes irrelevant. The document speaks, and it spoke clearly. Every month that payment continued, it reinforced a simple truth. Roles are not owned by those who temporarily occupy them. They are governed by frameworks that exist precisely to outlast personalities. The CEO could replace me. He could not replace the bylaw without exposing the very fragility he was trying to conceal. In retrospect, the most revealing moment came during a private board conversation relayed secondhand, in which someone asked whether the provision should be removed to prevent this from happening again. The response, delivered after a long pause, was decisive. Removing it would signal that leadership feared constraint more than instability. The motion never advanced. That was the correct decision. Because this was never about one executive's compensation. It was about whether governance is performative or binding, whether rules exist to be admired or obeyed, whether power answers to structure or merely assumes it does. In my assessment, the attempt to bypass the company's own safeguards in the name of expediency was not bold leadership, it was structural illiteracy. And institutions that tolerate that mistake do not fail dramatically. They erode quietly, one ignored clause at a time. The bylaw did its job. The system held. And anyone who believes this outcome was accidental fundamentally misunderstands how durable organizations are supposed to work. What followed was not escalation, but recalibration. Once the obligation was normalized, entered into forecasts, explained away in footnotes, absorbed into quarterly expectations, the organization did something institutions do when confronted with an immovable constraint. It adjusted its behavior around it. Authority was not diminished, but it was repriced. Decisions slowed, not dramatically, not visibly, but measurably. Termination proposals that once passed with a nod now arrived accompanied by governance reviews, annotated excerpts, and cautious hypotheticals. The board began asking questions it had not asked before, not because it had suddenly grown curious, but because it had learned, expensively, that certainty without verification is a liability. This is the hidden function of well-designed bylaws. They do not prevent action, they change the cost curve of action. The CEO, to his credit, adapted. He did not challenge the obligation publicly. He did not attempt to retroactively frame the event as a learning exercise. He did something far more revealing. He became careful. Careful with language, careful with process, careful with documents that previously lived untouched in shared drives and legacy binders. In effect, the organization rediscovered its own memory. There is a particular kind of discomfort that arises when leadership realizes it is not sovereign, merely temporary. That discomfort does not manifest as panic, it manifests as restraint. Meetings become longer, counsel is consulted earlier, decisions that once relied on instinct now require citation. This is not weakness, it is governance asserting its proper weight. Meanwhile, the financial obligation continued, indifferent to optics. Each payment was routine, automated, unemotional. No leverage remained. No narrative advantage could be extracted. The matter had passed from controversy into infrastructure, which is where all durable outcomes eventually reside. Occasionally, someone would ask, usually a newer executive unfamiliar with the history, why the company was carrying what appeared to be redundant executive compensation. The explanation, when given, was brief and carefully neutral: a legacy provision, a prior termination, an enforceable obligation. No one lingered on the details. They didn't need to. The presence of the cost was itself explanatory. It taught more effectively than any memo. Authority, everyone understood now, was bounded not by sentiment or hierarchy, but by structure, and structure, once activated, does not negotiate. There was in all of this a faintly Baroque elegance to the outcome, a system correcting behavior not through confrontation, but through quiet persistence. No speeches, no ultimatums, just alignment enforced by arithmetic. It is astonishing how persuasive numbers become when they repeat. By the end of the fiscal year, the company's leadership culture had changed in subtle but permanent ways, not softer, sharper, more aware of its own edges. The bylaw had not punished the organization, it had educated it. That is the difference between revenge and governance. One seeks satisfaction, the other seeks continuity. There is a temptation, when recounting outcomes like this, to personalize them, to frame the narrative around intelligence, foresight, or some implied tactical superiority. That temptation should be resisted. Individuals matter far less than the systems they operate within, and those systems matter only to the extent that they are respected. Nothing about this outcome required brilliance. It required attention. The bylaw was not hidden. It was not ambiguous. It was not cleverly exploited. It was simply read, understood, and allowed to function as written. The failure, therefore, was not one of law, but of culture. A culture that assumed legacy constraints were decorative, that authority could move faster than obligation, that documents mattered only when someone insisted they did. Such cultures persist until they encounter resistance that cannot be overridden by confidence. What made this episode instructive was not the financial duplication itself, but the asymmetry it revealed. One decision, made quickly and with minimal friction, created a long-duration consequence that no amount of executive momentum could erase. The organization learned, slowly, inevitably, that speed is not the same as control. In retrospect, the most consequential moment was not the termination, nor the discovery of the bylaw, nor even the legal confirmation of its enforceability. It was the point at which leadership stopped asking how to escape the obligation and started asking how to avoid triggering similar ones in the future. That shift marked the restoration of governance. Because governance is not about preventing mistakes. It is about ensuring mistakes are survivable. The bylaw did not protect me personally. It protected the role, the institution, and the continuity of decision-making across leadership cycles. That it also resulted in a personal financial outcome was incidental. The structure would have applied to anyone. That is its legitimacy. And this is where professional judgment must, briefly, override detachment. An executive team that failed to understand its own governing framework before exercising termination authority is not decisive, it is negligent. Power exercised without structural literacy is indistinguishable from impulse, and organizations led by impulse do not age well. The system won because it was designed to. It waited. It endured. It enforced alignment without spectacle or mercy. And in doing so, it reminded everyone involved of a truth that modern corporate culture too often forgets. Authority is temporary. Obligations are not. Long after the payments became routine and the incident receded from internal conversation, its secondary effects continued to propagate through the organization in ways that were neither dramatic nor accidental. This is the part of governance failures that rarely makes it into post-mortems, the quiet redistribution of caution. Executives who had not been present at the time absorbed the lesson indirectly. They inherited processes that now required cross-checking authority against documentation. They learned, without ever being explicitly told, that certain decisions carried invisible tails. Termination, restructuring, role consolidation, each now arrived tethered to a compliance review that did not exist before. This was not bureaucracy metastasizing. It was institutional memory being reinstalled. The board, too, adjusted. Informal assurances lost their persuasive power. Verbal consensus was no longer treated as sufficient insulation. When authority asked for speed, structure asked for proof. That tension never resolved, nor should it. Durable organizations do not eliminate friction, they allocate it strategically. Externally, nothing changed. There were no disclosures, no analyst questions, no proxy advisory commentary. The company's financials absorbed the obligation without visible strain, which made the lesson easier to ignore, and therefore more dangerous to repeat elsewhere. Only those close enough to the machinery understood what had happened and why it mattered. This is why governance failures are so often misunderstood. They do not announce themselves as crises. They announce themselves as inefficiencies, as unexplained costs, as decisions that seem oddly constrained by rules no one remembers approving. The temptation is to remove the constraint. The wiser response is to ask why it exists. In one internal discussion months later, a senior manager reportedly remarked that the situation was unfortunate but rare. That assessment was technically correct and strategically naive. Governance provisions are not designed for frequency. They are designed for inevitability. They wait for precisely the moment when authority becomes confident enough to forget why constraints were installed in the first place. The successor eventually moved on. Another appointment followed. The role persisted, and the obligation, bound to a term rather than a person, expired exactly when the bylaw said it would. Not early, not late, on schedule. There was no celebration, no sense of resolution, just the quiet disappearance of a line item that had, for a time, exerted disproportionate influence on executive behavior. When it ended, no one missed it, but no one forgot it either. That is how systems teach, not through spectacle, but through duration. This story is often misread as a tale of cleverness, of one individual outmaneuvering another through superior attention to detail. That interpretation is flattering but incorrect. Nothing here depended on ingenuity. It depended on respect for structure. Modern executive culture has developed an unfortunate habit of treating governance as ornamental, something to be referenced in annual reports, invoked during crises, and otherwise ignored in favor of momentum. That habit persists because most of the time it goes unpunished. Most terminations do not trigger legacy clauses. Most bylaws remain dormant. Most authority is exercised without consequence. Until it isn't. The moment authority collides with a binding structure it failed to understand, the outcome feels unfair, not because it is unjust, but because it is unfamiliar. Executives are trained to manage risk, not humility. They are rewarded for speed, not restraint. Governance provisions like this bylaw exist to correct that imbalance, not by opposing power directly, but by pricing its misuse. And here lies the final lesson, one that boards would do well to internalize rather than delegate. Bylaws are not technicalities. They are deferred decisions made by predecessors who understood that confidence decays faster than institutions. Ignoring them is not bold. It is illiterate. Revising them without understanding their purpose is worse. In this case, the system functioned exactly as intended. It imposed a cost where discretion had been exercised too casually. It outlasted the personalities involved. It restored equilibrium without requiring confrontation. That is not a loophole. That is governance succeeding. So if there is a moral to extract, and there is one, it is this. Power that does not read its own constraints eventually becomes constrained by them. Every organization inherits rules it did not write. The question is whether it honors them voluntarily or learns their value involuntarily. In my professional assessments, any leadership team that treats its governing documents as optional annotations rather than binding architecture is not merely exposing itself to financial risk. It is signaling a deeper incapacity to steward authority responsibly. And that, far more than paying 2 salaries for one role, is the kind of failure institutions rarely recover from.